Hi, everybody. I'm Gwendolyn Sterk of Sterk Family Law, and I have the honor and privilege to have Lou Plzak and Kathleen Dieckman of the law offices of Lewis A. Plzak and Associates. Thanks, guys, for coming out today.
Thanks, Gwendolyn, for having us. We're really looking forward to speaking with you and telling you a little bit about our business.
Well, thanks so much. You know, a lot of people don't understand certain aspects of the law, and my friends here, guys, do a practice in the area of workers' compensation and personal injury. So my first very simple question is, what's the difference?
Okay, well, basically with workers' comp, as you can imagine, it's a law that covers you when you get hurt at work. One thing about workers' comp, and the main difference between workers' comp and personal injury, is that it is a no-fault statute. So that means that you do not have to prove that somebody did something wrong or that there was negligence on the part of somebody, which is usually a really big hurdle to overcome. It's also what's called an exclusive remedy, and that if you do get hurt at the job, you cannot sue your employer other than filing a claim under the workers' comp statute.
All right, so then Kathleen, how does that differ from a personal injury claim?
A personal injury claim is a claim that you bring against someone else because of their negligence, and because of someone else's negligence, you were injured. And so the difference really with the personal injury and workers' compensation is you do have to prove negligence on behalf of the person that you are bringing a claim or a lawsuit against in a personal injury. And like Lou said, you can't, when you are injured at work, you don't bring a personal injury claim against your employer. You only bring a workers' compensation claim. But sometimes the two areas can overlap. For instance, if you have a UPS driver who is out making deliveries and he is in a car accident, and the car accident is the result of someone else's negligence and he is injured, then he can bring both a workers' compensation claim against his employer for the work-related injury, and for that same injury, he can bring a claim against the adverse party who caused the auto accident if it is not an employee of the same company, or it is not anyone from the same company. So there can be some overlap, but they are two distinct claims on both.
Okay,
cases.
and that's what's unique about your firm is because you do both, right?
Correct.
Yes.
Got it.
Yes.
Now, Lou, somebody is out there and they're saying, okay, I was injured on the job. Oh no, what should I do first? What would you tell them?
Well, the first thing they need to do is that they have to report the accident to their employer. The rules are that you have 45 days to give notice to the employer of your injury, and that could be in writing or orally or both. But then secondly, and I think most importantly, is you got to seek medical treatment. The longer you go with any kind of case that you have without getting medical treatment, there tends to be a presumption held against you that you're not really seriously hurt. And whether or not that's true, it's just the way the insurance companies act. So first thing is report the accident. Second thing is get medical treatment as soon as possible.
Now, Kathleen, does the same rules apply to personal injury, or is there a different format you should take?
Well, with personal injury, there's usually no employer necessarily to report it to, but you should have a police. It depends on what the personal injury is. If the personal injury, most personal injuries are automobile collisions. So if you're in an automobile collision, you should have a police report done right away. You should have it done. That way you're getting the identity of the other driver, their insurance information is being documented, and a police officer is coming to the scene and investigating. The other thing, if you have injuries, you seek medical attention immediately. Whether or not it's taking an ambulance to a hospital and or seeking medical attention from your own medical provider. But if you are injured or you think you are injured, you should seek the medical attention and get the opinions of a professional doctor.
Got it. Now, Lou, if somebody calls you and they say, okay, I was hurt on the job and I want to come and see you, how best should they prepare for that appointment or that first meeting with your office?
Well, generally, I'd like to get a lot of background information as to what happened. And I actually have a questionnaire that I have any potential clients fill out. I usually have them fill it out in advance so that I get an idea of what the case is about, and then I can prepare the documents that would be necessary for me to actually file the claim. Once I receive that document back or the questionnaire back from the potential client, then I would set up a meeting to either meet them in my office or at their home or just over the phone, depending on the circumstances.
And it's my understanding that you're the primary attorney at your firm that does the workers' comp claim. Is that correct?
That is correct.
And then Kathleen, you would do the personal injury claim. What would you say to somebody coming in that says, hey, you know, it wasn't an auto accident, but I was in the grocery store and a box fell and injured me at the grocery store? Can they come and see you for that, and what should they do?
Okay, because there's so many different types of personal injury claims that can happen, there's not one answer that would fit every type of situation. Every situation is unique. But if someone's injured on someone else's premises or at a grocery store or a retail, any kind of public entity, they should report it right away to the appropriate places. And if they're going to report it to the manager, they should report the injury and how it happened. They should also try to get a copy of whatever they report to the person in charge. A lot of times the retail stores or any kind of public entity, they don't want to give you a copy of the form that they fill out reporting your injury. So if they are refusing that, you could always ask, can I just take a picture of it before you leave? But everyone carries a camera phone nowadays. Get a picture so that you know what you reported and how you reported it to the entity or the retail store.
And when they come to see you, is there anything specific that they need to prepare for, or can they just call you and talk to you about the situation?
When they call me, I do a quite elaborate telephone initial consultation with the potential client. And I get a lot of information and figure out which type of personal injury it is. And depending on what type of personal injury, I'll go through and let them know what kind of documents I need to have and what they should be doing immediately in order to protect their claim currently, as well as any kind of future potential claim that they may have resulting from whatever matter they're contacting us regarding. So it can vary depending on the type of personal injury it is. A premise liability may be a little bit different than a car accident versus a construction case or a dog bite. So it depends, but we go through that quite thoroughly on the initial telephone conversation. And the only thing I tell people with a personal injury is if you are injured and you are going to be getting an attorney, if the adverse party's insurance company calls you, do not give any statements to them and don't sign any documents releasing your personal information, whether it's personal health or your employment information. Let the attorney take care of all that. You are not obligated to speak to the adverse insurance company. And it's better off if you are injured or think you are injured to talk to an attorney first and let them walk you through how to protect yourself and your claim.
It's really good advice, because I think people get panicked and they think they have to answer the question, just like if they get a bill in the mail for something. So Lou, tell us a little bit about that with regard to medical bills, especially in a workers' comp claim. So, you know, you have insurance through work. Should you be using that insurance? And you've heard the question before when you arrive at, you know, your doctor's appointment, is this related to an injury? So how should somebody start answering those questions if they were injured at work?
Well, 100%, we always advise our clients that whenever they get medical treatment, they need to let the doctors know how they got hurt. You have to establish that for any claim that you're going to try and bring. Now, as far as getting your bills paid, once you let your employer know that you've been hurt at work, they should be contacting their workers' comp insurance carrier. And then you have to get approval from the workers' compensation carrier before you get any treatment. If you don't get approval and you go and get treatment, there's a possibility that you could be stuck with the bill yourself, and that's something you would like to avoid. There are other instances where if you have health insurance and the workers' comp insurance is refusing to pay for whatever reason, then maybe you could use your health insurance, and then they might put a lien on the file, and we would take care of that on the back end of the case when the case gets resolved. But basically, it's not as you go, you always got to get approval first, and once you get approval, then you get the treatment that you need.
Oh, but I assume that excludes emergency care. Like if you got injured and you're bleeding out, you know, you're going to go get that emergency care. You're not going to wait first and get pre-approval.
That is correct. So emergency care. So one other step about that is under the Workers' Compensation Act, you are actually allowed to go to see 2 doctors of your own choosing and anybody that they refer you to. So if you want to go see your family doctor, then yes, you would have to get approval first. But if it is emergency situation, going to the emergency room does not count as one of those choices. So yes, you are able to go to the emergency room and get that treatment right away.
All right. Now, Kathleen, you got a personal injury case and somebody's, you know, in the same situation and they don't know where to turn and they don't want to be making statements, but they've got all these bills piling up and they're not sure what to do. Wouldn't it be best for them first and foremost to contact an attorney and really get guidance through this process?
Yes. As soon as you're in a car accident, and you think you're injured or you are injured, you should always contact an attorney as well. Certainly first, if you need emergency medical treatment, you get your medical attention first, okay? And like Lewis said, you always let the doctor know how you're injured. If you're in a car accident, you let them know you were in the car accident, and then let them know the body parts of their injuries that you have.
Got it. Well, here's the age-old question, Lou. Who's going to pay for this? I can't afford fees. So how does this work?
So both kind of cases that we have are what's called contingency fee cases. And so that means that unless we get a recovery for you, either by settling the case or by going to hearing and getting a positive result, then you would not owe us any attorney's fees. So it's really a no-lose situation for the injured person, because they have somebody who will be there to protect their rights and get them the benefits that they're entitled to. And then they won't have to pay attorney's fees unless they actually get a result.
Got it. And Kathleen, tell us a little more about how to get a hold of your firm and how people should get started in this process. So if they're listening to you today and they're saying, oh, I got a claim and maybe I shouldn't have done what I did, they can still call you and reach out, right? And get some help now.
They certainly can. Even if they've already taken certain actions, they should still contact an attorney. The attorney can walk them through or to go back and figure out what needs to be done based on the actions the client took. But if they are in an accident or have a work-related incident, whether it's personal injury or workers' compensation, they can reach out to us via telephone at 630-355-9233. And our phone line is always on. You can leave a message and we get back with you. We are very good about getting back with people within 24 hours. And if we can't speak with you immediately, one of us will reach back to you and let you know when a good time to speak with you, and at least give you some initial information so that you protect your claim.
Perfect. Luke, go ahead, and anything else you want to add in your contact info?
Yeah, I did. The only thing I want to say is that we always give free consultation.
Very good. And your contact information?
Again, same thing, 630-355-9233. Just give us a call and we'll help you out if we can.
Perfect. So if you're listening today and you had a personal injury situation or you have a possible workers' compensation claim, you've heard today the steps that you could take. And you know from us as a law firm that these claims can have a result in your dissolution action. So we always talk to you about those, and we try to work collaboratively to make sure that we're moving forward in the best way that we can. So again, important to understand what your rights and obligations are. And I think the tip that we got today for all of us is call early and get the information that you need. And if you have already taken steps, still call, because you need that help to move forward. So thanks, guys, for your time. I hope that the people listening today have learned a lot. Thank you.
Thank you so much,
Yeah,
Gwendolyn.
thank you, Gwen.
Take care.
Take care.
You too.